Welcome back. In today's video, I'm going to give a short overview of the family court for those of you that are starting on your family court journey. You're probably here because either yourself or your ex has made an application to the family court or thinking about making one, and this is all very new to you and can be very daunting. Your ex may have appointed family lawyers and you may be feeling somewhat overawed and on your own. Rest assured that you are not alone, as I'm here to help you. Well, the good news is that the family court is very different to the criminal court. You don't need to pay a fortune on outrageously expensive family lawyers and barristers to spend hours researching complex legal arguments, as the family court is based on procedures, processes, checklists, and taking a common sense approach to matters. I'm here to help you on your journey with my series of short educational videos, and if this is of help, then I suggest that you press the subscribe button below to ensure that you get my next videos. The basic steps in the family court are: Step 1. Before you make an application to the court, you, your ex-partner, or both of you will need to attend mediation, either in an effort to try and resolve matters or as a requirement of the court application. This is known as a MIAM, Mediation Information Assessment Meeting. You can try mediation to see if it helps, and more often than not, it can be a one-off meeting by the person making the application, known as the applicant, to ascertain that mediation is not for them and hence qualify for making the court application. The next step is completing the C100 application form and sending it to the court, and this can be done online. The other party will receive notice of the application, and they are known as the respondent. You'll receive a notice of the application and instructions to attend court on a certain date, with directions of what is required. Your case will be allocated to either a judge or magistrate. Judges are more senior than magistrates, and there may be 2 or 3 magistrates allocated together, which is known as a bench. If this is a child arrangements application, then the court will also allocate a CAFCAS officer to your case. CAFCAS is the Children and Family Court Advisory and Support Services, and their role is to ensure the safety and well-being of your children. They will make an appointment to speak with you and your ex, and they will provide what is known as a safeguarding letter for the court and make recommendations on your case to the court. I'll be covering the initial CAFCAS call in my next video because it's a very important call. There are typically 3 hearings in the process. However, there can be more depending on the complexity of your case and if there are any allegations of abuse made by either party. The initial hearing is the first hearing dispute resolution hearing, which is also referred to as a FEDRA. The second hearing is a dispute resolution hearing, where the parties are encouraged to negotiate and try and find a resolution to child contact arrangements. However, if that is not achievable, then your case will go to a final hearing where the court will decide and give a judgment on your case and outcome. Now, unfortunately, there is often a high degree of conflict and acrimony between the parties, which is understandable, and this is heightened due to the court process. There is typically allegations and mudslinging thrown by both sides, which doesn't help the case and is actually emotionally harmful for the children who are caught up in the middle. Whilst it's not easy and often unavoidable, it would be far better for everyone if there wasn't any, and I'd encourage you to try and move forward in a positive, co-parenting way. However, I know that isn't always very easy to do. You need to understand that this is a court of law, and the court will not make decisions based on mindless allegations. The court will make their decisions on evidence and facts. Therefore, before making any allegations, you need to consider 3 highly important points. Point 1. What evidence do you have to support your allegation? If you have no evidence, then you're wasting your time. Secondly, what is the relevance of the allegation to the case? Making mindless allegations of the other party's conduct during your relationship or their parenting style is not relevant to matters now. Your relationship is already broken, and blaming each other is not relevant to your case or the outcome of the hearing or what the court wants to hear. If you have evidence and it is relative to the case, then ask yourself, what do you want the judge to do about it? If you don't know, or you just want the judge to be aware of it, then it's pointless in raising it. You must know what action you want the judge to take as a result of making your application, as the court will only make decisions based on facts. Allegations are not facts. They are merely one person's claim of what the other party has done. You will need to present clear evidence to the court and not hearsay. Once the court has considered the evidence of both parties, then the court will decide if or not it is indeed fact. This will be established in what is known as a fact-finding hearing. This will typically be a 1 to 3 day hearing and can even last as long as 5 days in extreme cases. The fact-finding hearing will also delay the process by 4 to 6 months. I therefore suggest that you may want to think very carefully before making allegations, and always say to yourself, what do I want the judge to do about it? Well, thank you for listening. That's it for today. So hit the subscribe button below and look out for my next video. And if you want a free consultation or chat about your case, then go to www.McKenzieFriendConsultants.co.uk and book your free call with me. Bye for now.